Right, so good evening everybody and welcome to the CIPIL lecture. Today we are welcoming Dr. Chen, who is a lecturer at Durham University, senior lecturer at Durham University, or assistant professor. And he's also co-director of what will be a Center for Chinese Law and Policy, which is coming to fruition in the next period. Let's see, Guy has just published, last year published a book, which is Copyright and International Negotiations, an Engine of Free Expression in China, and that is CUP 2018. He has research interests in copyright, trade, intellectual property, and particularly in free expression. And today he's going to talk to us on how copyright affects free expression, a perspective from Sino-US trade war. So let's welcome.
Well, thank you very much, Jennifer, for your kind introduction. And also, I'm very excited to talk about this book, because Jennifer kindly asked me to talk about my book. I haven't had many chances to talk about it yet, for some reasons that I would explain later. So, it's about, well, the book is about practically both freedom of expression and copyright and trade. So what I wanted to say here is that I endorse the Sino-US trade law. So from the very beginning, I should just articulate my standpoint, because the trade war is a very good engine of facilitating copyright development in China, which in turn would promote freedom of expression in China or in some other countries, or many countries as well. The problem with the trade war started earlier this year, in March. So President Trump relied heavily on Section 301 of the Trade Act. So in that Trade Act, we have a special 301 report. And in this report, the U.S. government would, on an annual basis, name some countries that allegedly violated the IP of the U.S., and then put the country on the list to watch, to observe whether it will comply with the IP law. But generally, this issue is what sparked the Sino-US trade war. So in a historical perspective, we will find that almost all the Sino-US trade frictions started with IP issues. So you see that starting in March, the U.S. administration charged China for unfair trade and theft of IP, amounting to about $60 billion US. So the Trump administration imposed some sanctionary measures on imported Chinese goods correspondingly. In this book, or in the area that I've been researching, I mainly focus on these issues. First, are there any general exception provisions in WTO law, such as Article 20 of the GATT, which legitimizes the trade barriers of some countries on the ground of public interest, right? And so far as copyright is concerned, we have Article 17 of the Berne Convention, which is incorporated into the TRIPS agreement, which allegedly also legitimizes some censorship of intellectual works, which China heavily relied on in a case at the WTO. And finally, would these public interest, or so-called public interest, such as Asian values, ultimately legitimize the control of freedom of expression? With these questions in mind, we can start to talk about the copyright issue in China. First, I would briefly explain the origin of copyright in historical context in China. Confucianism. What kind of relationship is there between Confucianism and copyright? Because Confucius largely preached hierarchy and virtue and obedience in the Chinese society. And in this sense, it has some implication for intellectual works, which is, so in a traditional sense, the Chinese intellectuals are not supposed to be concerned about the connection between financial interests and the intellectual works that they created. This would have been deemed shameful in ancient China. And you might have heard a famous saying, which has been turned into the name of a famous title on copyright. Stealing books is an elegant offense in China, but not benefiting from selling the books as an author. So, in this sense, copyright has been suppressed in the ancient Chinese society. On the other hand, we have censorship in China for a long time already. According to a very famous Chinese copyright lawyer, who have also studied in Cambridge, I think, he said, in fact, you can presume that copyright in China originated in the Song dynasty around 1000, AD, so which is about the time when the University of Cambridge came into being. So he said copyright came into being in China at that time, with which many lawyers or Chinese copyright lawyers did not agree, because what could be named as copyright at that time was almost equivalent to censorship. So the Song Code, which is the law summary or compilation of the law in the dynasty, forbids explicitly unauthorized printing. That was what this scholar meant, probably. And that law lasted throughout the ensuing dynasties such as Ming and Qing dynasties, both of which had this kind of summary or compilation of laws, and contained similar rules to those on censorship in the Song Code. What is famously written there is, whoever makes copies without government authorization will be prosecuted. So in those days, the Chinese intellectuals lay so much emphasis on the government examinations presided over by the government. So through these examinations, you would be able to rise very high to a government post, and there you get rich spontaneously without selling books. But those who wanted to sell their books on the market might get punished. And this meant that the printing industry in China had been suppressed for a long time, although the printing technology came into being first in China. Then, at the end of, or towards the end of the Qing dynasty, which was the last dynasty in China, copyright had a good chance of growth, and also with a humiliating history in modern China. This picture showed, which is familiar, you might be familiar with the national flag. That was the beginning of the Opium War in China, which had a long, everlasting impression on many Chinese. And the Chinese leadership always named it as 100 years of humiliation. However, with this history, copyright was able to come into being in a formal sense. Shortly after the Opium Wars, China had many other defeats, with Japan, with some other European countries, with France, for example. So the purpose was to knock open the door of foreign trade in China. So just note, foreign trade became a word now towards the end of the Qing dynasty. So in the beginning, many Western missionaries were able to preach their teachings in China, right? So they had many publications, both in Chinese and in English in China. And of course, with that, there was a thriving publishing industry in the mainland. And these Western missionaries did these things pro bono, so to speak, in the beginning. But with time, they found that this was not a good idea because they need to live, somehow and get something to live on. So what they were thinking about is to develop the same idea of copyright in China. However, the Qing government had no copyright system, right? Nobody had an idea about, awarding the authors in China according to the traditional concepts. So what did they do? What did these missionaries do? They started at the same time to import many books from the US, from the UK, and then they found it was impossible to do so constantly without copyright protection. So that's why they had a chance when China had a big defeat in the first Sino-Japan War, so that the Qing government was determined to develop their laws in the Western way, because many intellectuals were arguing that the reason why China became backward was China had no legal system like that of Japan or the European countries. So the emperor decided to learn from Europe and sent some ministers or his subjects to to European countries to study business law, constitutional law. And at this time, the U.S., prompted primarily by some industrial companies or publishers, started to talk with China about copyright in their commercial negotiations. This was what I call the first trade friction or trade talk, you can say. So trade war did not start in 2018, but at the end of the Qing dynasty. That's my view. And Sino-US commercial negotiations always focused on copyright in the beginning. And what was a question at that time is that the Qing government was very reluctant to grant copyright to Western publishers because they were afraid that the more liberal these writings could be, the more dangerous the ruling, their monopoly on the power, could become. So they took it as a kind of chip, in the negotiations with the U.S., with Japan. And what came in the end was several treaties in which China agreed to grant copyright to these Western publishers, whereas the Western government must in return allow the Chinese government to conduct censorship and help the Chinese government to conduct censorship in their own countries. So an example was the Japanese government, for example, promised that they would give priority to suppressing the speech and writings of Dr. Sun Yat-sen, who was the founding father of the Republic of China, if the Chinese or Qing government granted copyright to Japanese publishers, because there were many Japanese writings coming in, to China. Many intellectuals were looking to the Japanese writings. So Japan also had a great interest on copyright. And the treaty required China to grant copyright, but China could ban, eventually, those works that interfere with the public order, public security. And now we are approaching the end of the Qing dynasty, and in 1905, the Qing government sent out a delegation to Berlin to attend the diplomatic conference of the Berne Convention, with which they started formally to prepare the first copyright code in China. And successfully they did. We had a complete record of the statute at that time. However, unfortunately, this code did not come into effect finally, because just 2 years later, the Qing government was overthrown by Dr. Sun. And then this copyright code became a historical archive for the coming nationalist regime, which also initiated some copyright legislation based on German copyright law, because both the emperor of the Qing government and the leadership of the nationalist regime were of the opinion that German law should be the best example because Germany had an emperor still at the time and practiced constitutional monarchy. So Japan learned from Germany, and that was presumably why Japan was able to defeat China in the humiliating war. That's what the emperor said. So then we come to the People's Republic. In the beginning, Mao, Chairman Mao, you say, had no interest in copyright law whatsoever. And in the beginning, however, they declared all the laws in the nationalist regime void, invalidated all the laws. And there were practically no law at that time. And the Chinese government started to initiate some administrative rules on copyright in the 1950s. However, there were only state-owned publishers at that time. And the rules had certain content of publishing contracts. But these contracts were predetermined by state plans, which is to say, as an author, you could get some remuneration only from the government, but not from the market. And you can only have remuneration on the basis of certain financial guidelines determined by the government. So you get 10 cents for for 10 Chinese characters, maybe, according to a state plan. So the financial interests of those authors were still considerably suppressed by the Chinese government, and there was basically a natural tension between the Chinese Communist Party and the intellectuals. As Chairman Mao said at that time, so literary works are simply based on daily life of ordinary people. So we should not regard an intellectual work as anything, marvelous, like a marvelous creation. Why should we give these authors money, right, to make them corrupt? And another famous proverb during the Cultural Revolution, which is a disaster in China, of course, for intellectual works, is that Mao said, the more knowledgeable one is, the more reactionary or counter-revolutionary you are. So generally among the Chinese citizens, there is a kind of contempt for benefiting, for profiting from one's own works. And this came simultaneously with many policies of the control of free speech, which means you can't write freely, but the general public had a generous alternative or access to intellectual works. There were many free public libraries at that time, and the public could get access to any intellectual works, so to speak. That was the policy of the Chinese Communist Party. And then the Chinese nation had a very difficult time, of course, in the Cultural Revolution. So towards the end of the 70s, Deng Xiaoping came to power. And there was a relatively peaceful period during the 1980s with regard to economic development. So Deng was much more liberal-minded, as many people remark, and he allowed private ownership to grow in China, probably because he saw that was the only alternative that China had. And of course, with this, the authors or copyright owners had a chance to enjoy private ownership of intellectual works, which became gradually recognized in the laws. In 1986, China had its first civil law code, which is a preliminary or primitive form of civil law. But still, in that code, it said, so everyone has a right to benefit from his own intellectual works. That was the beginning in the People's Republic, in a formal code like that, which allows copyright owners to enjoy private ownership. And copyright protection, on the other hand, argued many politicians might benefit cultural propaganda for China, because the Chinese government had a very important say on whether this copyright law should be initiated or passed finally. So it was necessary to convince the government of the need to initiate a new copyright code in China. So the reason many people argued was that China might benefit from foreign trade, because the U.S., we need a frequent contact with the U.S., with Europe, so they value copyright very much. We need to have copyright as well in order to exchange something with them. So the government was almost persuaded to do this. At the same time, we had trade talks, as I said, trade frictions always accompanied the growth of copyright in China. So from the end of 70s to the end of 80s, the US tried its best to press China to develop its copyright law. And towards the end of 80s, the US started to apply this 301 provision and initiated the first special 301 report, and even placed China on its priority watch list, which was second to the worst on the list, which means it's very serious, but we still need to observe. And then in that year, we know that many things happened in 1989, including the first Sino-US Memorandum of Understanding on Copyright after the founding of the People's Republic. So the US basically requested a new Copyright Act in China. That was the US firm standpoint, saying you must have a new copyright code rather than these sporadic regulations and rules. We need a complete system of copyright laws to protect our intellectual works in China. But at the same time, the complexity of tension between copyright and control of free expression in China became more obvious, because in that period of time, there were many intellectuals who were deeply influenced by Western ideas of democracy. And towards the end of the 1980s, we had the democratic movement, right, on Tiananmen Square. So the background was that many intellectuals were free and able to write and publish their writings, especially between 1985 and 1989. So they were able to publish, sometimes without remuneration, sometimes even without large economic benefits. The government saw this and was aware of this problem. So that was the background of the first Copyright Act in the People's Republic. The institutional nature of the 1990 Copyright Act, which came into being at that time, was that copyright was largely overshadowed by censorship. So there were serious talks within the legislature, the government, before the Copyright Act was enacted. The main focus was whether the Chinese government would be able to defend its standpoint if they allowed copyright to develop so freely in terms of the Western copyright laws. There were such records of talks in the Chinese government. But on the other hand, there was a seemingly high degree of public access to intellectual works, which was good for the Chinese citizens because many people enjoyed the state. People were free to pirate. People were free to make copies. People were free to get access to any intellectual works that they wanted to read. So, indeed, among the Chinese citizens, there were many people who did not want copyright because otherwise they may not be free to read these works. Some intellectuals argued. So in the law itself, what did we have at that time? we barely had national treatment. There was a high degree of control of foreign works in the first Copyright Act. So China was still not a member of the Berne Convention at the time. So that the first article in the Copyright Act did not grant copyright completely to all those foreign works in accordance with the Berne Convention. And secondly, the authorship. So many authors, according to the Copyright Act, would have to subject their economic interests or remuneration chances to the units for which they work. You know, China was traditionally has been a country of planned economy. So before the 1990s, almost no one had a private identity, private economic identity. So these authors all belonged to a state-owned unit. So that they would have to submit their works to the units for which they work. And the economic benefits should also be submitted to the units, although they might get something in return through negotiation with their units. So there was heavy suppression of authorial interests still on the basis of the Copyright Act. As for the subject matter, there was a high degree of originality. This was very interesting because, as I said, according to Confucius, nothing in the intellectual works is new. So everything is based on things that people said before. So in order to get something in return for the works that you created, you need to show a high degree of originality. So for example, if you compile something like a TV program in a newspaper, this is something in a copyright case in China, it would not be recognized as copyright. So free use, state interests dominate considerably. So states would be, the government would be able to use intellectual works freely in general at that time. Compulsory license, well, till the end of the 1980s, the state controlled almost all the media facilities in China. So it didn't matter so much whether there was a compulsory license for the media facilities or not, because it was ultimately the government which was able to make use of the copyright. Most importantly, there is an article in the Act, which is the Article 4, censorship provision, I call it, which became a problem later on in the China-US dispute. It says that works lawfully banned from publication in China would not be protected by copyright law. So, in the beginning, domestic lawyers, copyright law professors argued that this was a problem because, after all, copyright could be seen or perceived as a constitutional right in China. However, this law, copyright law, was part of the so-called civil law, because China is also largely a civil law country. It's part of the civil law, so you can't negate the validity of a constitutional right by a civil code like this. But problems came also with the legitimacy itself of censorship. So if you take a look at the Berne Convention, which China became a member of 2 years later after this act, you will find potential conflicts between this provision and the Berne Convention in general. So first, it had a conflict with the national treatment. So if you granted copyright to some foreign works and not to the others which might be censored, then you don't have an equal treatment, right, under national treatment. And secondly, the Chinese code added an additional prerequisite for granting copyright protection. That is, the work itself has got to survive the censorship. So it had a potential conflict with the minimum standards request under the Berne Convention too. And thirdly, the Berne Convention did not require any formality for granting, for getting copyright. So through this Article 4, Chinese copyright law, also had a conflict with the automatic protection under the Berne Convention. And finally, most importantly, according to the TRIPS agreement, because China joined WTO several years later, the most important thing is the idea expression dichotomy there, which had an influence on the Chinese law later on, Chinese copyright law. So if you distinguish the copyright protection in terms of whether it could survive the censorship, you actually violate the idea expression dichotomy, because copyright is not based on the idea itself, but it's based on the expression, right? So the censorship regime itself was based on, the quality of the ideas. Now, the post-Deng 3 decades saw a bunch of trade talks and frictions which reshaped China's copyright law considerably. Starting in 1989, the US started its sanction on the Chinese government after the Tiananmen Square movement, together with its negotiations on IP. So the US government was very clever. It made use of the political incident as a pretext to strengthen its chips in the trade talk, which focused on copyright at that time. So after 2 years, in 1991, China and the US were on the brink of a trade war. It was very, dangerous. Many people argued because both governments had a detailed list of economic sanctions following the failure of the copyright trade talk. And the US trade representative claimed a copyright loss of about $400 million at that time, right? So piracy of American film industry, CDs, films, books, whatsoever, and threatened about 100% tariffs worth $1.5 billion. And China also had its corresponding sanctionary measures in pipeline. Now, China was placed on priority foreign country, the highest rank according to the Special 301 report. And in 1992, finally, strangely whatsoever, China and the US reached agreement at the last moment on memorandum of understanding on copyright again. So in this memorandum, China agreed to accede to the Berne Convention, which was the request from the US, and agreed to revise its Copyright Act in accordance with the Berne Convention. This was very important. So, because probably China wanted to pursue its status in the World Trade Organization, which came into being 2 years later. So China was had its chips, agreed with the US. What happened afterwards? Just after this memorandum, Deng Xiaoping, he was really very old, so he visited the southern part of China and gave a special and famous speech on developing socialist market economy, which meant in the Chinese context that private ownership must develop freely. So, which had a very considerable influence on the Chinese policies and leadership later on. During the following years, China was able to promote the status of copyright and intellectuals, so that China had a large revision or amendment of the copyright law and enacted many copyright regulations in terms of the Berne Convention, which allowed, importantly, foreign works to get copyright under Chinese law, specifically. So at that time, the Copyright Act was not amended, had not been amended yet, But at the same time, the Chinese government enacted many laws to grant copyright protection to foreign works. And then, at the same time, there was a stringent control of the free flow of information, which is that the Chinese government ushered in a stringent crackdown on the book markets, which the Chinese government did to cater to the needs of the US government in the trade talks. So to crack down on piracy on a large scale, so that the Chinese government was able to develop the so-called strategy or regime of a regular campaign on piracy and counterfeited products. And finally, it only led to more rampant piracy in China, because that was the period of time when the Chinese were really becoming more aware of Western ideas. And many people were so curious about the ideologies and ideas, economy, liberalism, democracy from foreign countries, so that people spared no efforts in piracy. So I still remember that time when I was in Shanghai, that every night after dinner, you could go to the street, and then you have a very dynamic market on the street of selling those books that you couldn't find in the daytime. So you were really able to get access to almost everything you wanted to read. But strangely, this became a problem. Well, it's not strange. This became a problem for the U.S. government, of course. And then in 1995 to 1996, again, there were trade frictions between the Chinese government and the U.S. And we had Sino-US IP talks again. This time, however, on IP enforcement. The U.S. said, you had copyright law, you had a bunch of copyright regulations there which cater to the Berne Convention. However, the problem is its enforcement. Please, do enforce your laws. And then the U.S. raised many high requests for enforcing the IP laws in China, whereas China took these as a kind of measure, as usual, as a chip to get something back, to get something in return. Finally, both sides reached agreement again because China had an important chip in becoming a member of the WTO. So the Clinton administration finally reached an agreement with the Chinese government. Again, need to quicken. So that was the amendment of the Copyright Act later. So we had an institutional nature again in this amendment, different than that in the 1990, which is the copyright enforcement was largely strengthened, right? So we had a stringent control of public access to intellectual works. Berne Convention national treatment was incorporated into Chinese law. Economic rights, for the first time, became a word in the Chinese Copyright Act itself. Never before did we have a wording like this, economic rights, which was against the policy of the Chinese Communist Party in the beginning of the People's Republic. And then we had some neighboring rights which enhanced the remuneration of copyright owners, but it was largely still burdened by media control in China. And we have this system of free use, which, however, had some difficulty for the courts, because the courts was very confused about how to differentiate commercial interests from the so-called non-commercial interests in the law. So we had a case at the time, for example, the same author, Mr. Hu, brought a proceeding against several publishers at the same time, including the National Examination Center of the Chinese government, because the center used his copyrighted protected materials for examination in China. And the court in Beijing held that this was not copyright infringement because the state used the materials in the public interest. According to Chinese law, it was a kind of free use. However, at the same time, several other courts which accepted Mr. Hu's lawsuits found that there was copyright infringement by several other publishers which, without authorization, published Mr. Hu's materials as a preparatory material for the examination. So the court said this was copyright infringement on the ground that the publishers had a private interest, commercial interests in these cases. So it was confusing in the beginning. And then we still have compulsory license, largely burdened by media control at the same time. What was marvelous was this article, 47, which allows copyright administrative departments, it was based on the previous practice, of course, in China, to adopt any measures to enforce copyright protection if infringers violate both the private interest and the public interest. This was a very interesting provision in the Chinese copyright law because it allowed practically the government agencies to determine and to define what was public interest. So in practice, in a study, statistical study, it found that there was a stringent control of the free flow of the information in these campaigns because the government agencies waged regular campaigns, so-called anti-pornography and anti-illegal publications. It had even a permanent working office in the Chinese government with regard to crack down on these pirated works, as they say. But in fact, 1/3 of these works were pirated works, according to the statistics published by the Chinese government. The rest, 2/3, were unknown. So what kind of works have been prohibited from circulation in this crackdown campaign? And there has been an annual campaign of purifying the internet since 5 or 6 years ago. Now, in this table, I'd like to show you a unique structure of copyright administration in China. So on the left side, you have this so-called party structure, the Chinese Communist Party. On the right side, the state structure. So China has been constantly called a party state, right? Before this year, 2018, before the government reform in March, you have two completely separate organs in the party and the state. That is, the Chinese Communist Party Central Publicity Department, which is in charge of ideology control. But before this year, it had always been located in the party itself. And in the government, we always had the same team with two titles. That is, the National Administration of Press and Publication and the National Copyright Bureau. This has been a constant practice in the Chinese government since almost the founding of the People's Republic. And the name has been constantly changed several times. And now, since the start of this year, its formal title is National Administration of Press and Publication and the National Copyright Bureau. So together with these two organs, there was another organ, National Film Bureau. These three organs are now located in the same building as the Central Publicity Department, and is explicitly under the administration of the party organization, which was amazing, which almost proved one of my theses, which is to say copyright law is different from the other parts of intellectual property law in China. As you see clearly from this year's new table, the National Intellectual Property Administration which is in charge of patents registration, trademark, geographical indication, and so on, is located in the central government in a separate branch and building, and has almost nothing to do with copyright. So this is a unique table that I would like to present, and then a picture beginning of this year was made. You see that on these three plaques are just those three organs that I just named, that just showed you, in the same building as the central publicity department of the Chinese Communist Party, which is amazing. So if you, as a copyright lawyer or copyright law professor, if you had a chance to visit China and wanted to visit the highest authority of copyright administration, you probably need to go to the Chinese Communist Party department to meet with them. And strangely, the offices has been established now since 6 months ago. And yesterday I had a check. There is still no information about the composition of the team, about any laws, regulations as before on the website of these two. There is a website for these two organs, National Administration of Press and Publication and Copyright Bureau. But there's no substantial content in there. I suspect that the team has been reorganized and synchronized with the publicity department itself. Very likely. So this is an article that I wrote about the big dispute, because I just received an email from Henning saying that he had a lecture 2 days ago about the Sino-US copyright dispute, IP dispute at the WTO. So he asked me if I had any new or old literature on this. So in this article, I argued, for instance, that China had cleverly made use of the strategy in international law, including the WTO international copyright law and international human rights law. So in that year alone, I won't go into detail because you probably had a lecture already. What I wanted to stress is simply the fact that in the same week in 2009, Geneva saw two different groups from China arguing in a different way about China's copyright and free expression. In the UN Human Rights Council, in the Universal Periodic Review, the Chinese delegation said there was no censorship in China. We have a systematic media facility which serves as a good watchdog for the government. There's no practically any censorship. Copyright is, of course, no problem. Whereas at the WTO panel, China was arguing with the US and the EU, and the delegation said, well, copyright is certainly a legitimate practice according to the Berne Convention, because we have Article 17, which allows members to prohibit dissemination of some works from circulation in terms of the public order. An interesting thing. So I'm coming gradually to conclusion. That is, in this world, we have several types of, regulating copyright and free speech in different parts of the world. I always like to use this picture. In the US, you have a First Amendment which almost narrow-mindedly, could say, or single-mindedly focuses on the restriction of government power and prohibits any interference with any speech that is engaged with the public topic. So typical cases are New York Times and Harper and Row versus Nation Enterprises. So very strangely, you have almost the free speech always as a top priority against any other private rights infringement, such as privacy, defamation, data protection, hate speech, for example. However, in copyright, the US courts appeared mildly neutralized. So in this landmark case, for example, the US courts unanimously held that whether a claim of news reporting is valid a fair use defense to an infringement of copyrightable expression was the main focus in that case. So it didn't allow First Amendment to trump copyright, namely fair use doctrine under US law in this landmark case. Of course, there are some more ramifications later on, but copyright is, after all, also a constitutional clause in the US. Whereas in the EU, we always have a balancing approach. So in the US, you have a First Amendment priority approach. In the EU, you have a balancing. So about five years ago, we had the first case in Europe with regard to the potential conflicts between copyright and free expression. And the European Court of Human Rights held that recognized the potential conflict between copyright and free speech, and warned that courts should take care with regard to balancing these two rights. And in particular, the copyright law enforcement, said the court, must be conducted in accordance with Article 10 of the European Convention on Human Rights. What I wanted to say is, in China, or first, in general, we have this pattern, or this relationship, which I developed in my book. That is, the relationship between copyright and free expression is basically first based on these two pillars of copyright. That is, access to remuneration, copyright owners' interests, private interests, whatever you call it. And on the other hand, public interest, access to knowledge, many people call, right, as a recent movement. And then, under freedom of expression and human rights law, basically you could argue that there is a distinction between freedom of speech on one hand, generally as an author, right, as a creator in copyright discourse. But in human rights discourse, as a citizen, you enjoy free speech. On the other hand, as the general public, you enjoy freedom of information. So these two freedoms are a little bit different from each other, right? So the free flow of information. And correspondingly, if you compare these two pillars under copyright law and two pillars of free expression law, you can somehow establish a link between these pillars in every country almost. So what I did in this study is I found that the Chinese government managed to control free expression by manipulating these two pillars under copyright. So as I just explained, in the first political and economic scenario, the authors had limited access to remuneration, right? Whereas the general public had free access almost to intellectual works. So access to remuneration was suppressed, whereas access to knowledge came up. And the Chinese government was able to claim we still have a copyright because the relationship and interplay between these two was a natural process under copyright law itself. So you didn't see anything in the beginning. So what was in a normal country, market economy, was an invisible hand waved by the market. So you have access to remuneration, you have access to knowledge. If you have a too high price for the works, then the general public would have a lower chance of getting access. So seemingly it had no problem. However, behind the Chinese copyright law, there was another hand in work. That is the government's hand. So what the Chinese government did was to suppress, the purpose was to suppress free expression here. So if you pin down the remuneration, right, the authors could not get anything. You lose motivation to write any works. Well, of course, there are still many authors who wanted to write, but the majority would lose interest in becoming an intellectual. Whereas in a second scenario, you have this copyright infringement crackdown or campaigns regularly on work, and then the government is trying to crack down on the public access to the free flow of information. So seemingly, copyright owners had a very good chance of getting access to remuneration. Many authors did become very rich during the 1990s and in the first decade of this century. Whereas the public has more difficulty compared with the 1980s to get access to works, intellectual works. So in this way, the Chinese government was able to manage free expression in China. However, as I argued, there are two engines for free expression in China. One is copyright itself. The other one is trade talks, trade frictions, or trade law, whatever you call it. So on one side, you have this invisible hand from the Chinese government, censorship on copyright. On the other hand, you have trade war. So 2 years ago, in 2016, the U.S. government, the U.S. Trade Representative, presented its first ever report in which it named explicitly the Great Firewall and censorship as a trade barrier, together with other IP issues. This was very interesting. I was guessing that maybe the U.S. might take China later to a WTO case in which it argued now, more than the case in 2009, that copyright or other intellectual property rights linked together with censorship constituted a serious trade barrier. That would be very interesting. So behind this, my final words, the trade war, you can say, is a value confrontation, I would argue. So throughout the Clinton and Bush and Obama and Trump administration, they might have different policies on trade and IP, but there's a one red ribbon that is throughout these IP talks, always name it as trade or commercial talks, but it always focused on IP and copyright in first instance. You always have this problem with copyright, with piracy, which was prompted fundamentally by a censorship regime in China. And then some people argue that the TPP, which Trump pulled out of or withdrew, U.S. withdrew from the TPP, the beginning of Trump administration. In fact, in my opinion, Trump is now still organizing some kind of, trade allies with the EU, with Japan, on the basis of some constant values. That is the free flow of information, which is one of the fundamental spirit of the TPP, together with data protection and IP. My thesis is summarized then in this book, which was published last year. And luckily, I had a mention in Harvard Law Review earlier this year about the book. I guess probably because the Harvard Law Review editors saw a chance of, starting the talk or trade talk with new round of trade talk with China in March. And exactly, it turned out that the U.S. administrations started its trade war in March. But as I just told Jennifer, the book is not available or has not been ever available on the Chinese market, which is potentially my largest audience. Right, because that was very annoying. I had a look, all the other Cambridge IP titles, almost every title is there, except mine. And I learned last year from the press that it got a problem with the Chinese government, and you know that the Chinese government explicitly ordered the Cambridge University Press to take down a few hundred titles, academic titles, with regard to China studies. And my title is among them. And still, after that, the press sustained a lot of pressure, I know, from the Western intellectuals as well. So I hope the press is still fine with this till today. But while I could not enjoy my copyright in China, I take comfort in saying that this is a high compliment from the Chinese government. For censorship means that I might have said something relevant. So I would like to stop here and maybe open to question.
Yes.
Yeah.